All right, we're going to conclude with our presentation on an update of the 88th legislative session. There have been a number of developments, a number of pieces of legislation that the commission was involved with. You're going to hear about those in just a moment. And we're going to finish up strong here with our two presenters. To my right, Judge David Newell. Judge Newell has been a judge in the Court of Criminal Appeals since 2014. Prior to that, he was an appellate prosecutor for 16 years, both in Fort Bend County and in Harris County. To my left, Judge Ryan Turner is Executive Director of the Texas Municipal Courts Education Center and a substitute associate judge in the Austin Municipal Court. Before joining the center, he served as a briefing attorney for Judge Sharon Keller on the Texas Court of Criminal Appeals, and he is on the Commission's Collaborative Council. Welcome to Judge Newell and Judge Turner.
Thank you. Thank you very much. So I'm waiting to see if we can get the PowerPoint up here. Nope, go back. That's next. Okay, so yes. So I'm David Newell, and I don't know why I'm here. But I'm glad to be here. Ryan and I are good friends. We've known each other for a while, and we're going to talk about the mental health legislation update. We were given sort of a roadmap. Really what we're looking at trying to do is give you sort of a broad overview of some of the things, to highlight some big things that happen. Any of you are familiar with the legislative process? It is not quite the rewarding, idealistic experience featured in Schoolhouse Rock. It can be a little bit rough, and so some things, we're going to talk about some things that made it, some things that didn't. Before we get started here, though, we're going to split it. We're going to go back and forth here. I am standing because Ryan wanted us to stand.
I'm going to sit.
And you're going to...
I think you're right. I think we should sit.
That's right. So, yeah. So now I'm committed to the standing part. So I'm going to. And anyway, but the first thing I want to sort of get out of the way here is, like, just to emphasize this, this is, if you may or may not know, this is DJ Jazzy Chef and the Fresh Prince. I like to think of it like I'm really just the DJ here. He's the rapper. He's the one that knows all this stuff. So if you want, if you want to get the flow, he's going to give you flow. I'm just the guy that puts the PowerPoint together. And so the thing that's sort of interesting about this is that when between the two of us, they specifically were like, they asked us to do that, and we were like, why? Why us?
Why
us? Asking us to do this?
Why us?
Why? Because he's on one end of the spectrum of the system here, like where he's at the magistrate level as an associate judge and an educator for Texas Municipal Court Education Center, and then I'm on the high court in criminal cases in Texas, and I don't even do like juvenile. Like so I'm like, okay, awesome. We'll give it our best shot. I think that what they wanted us to do was to make it entertaining, like DJ Jazzy Jeff and the Fresh Prince. So that's what we're going to try and do. We hope that it helps you out. I hope you find something interesting that you get from the presentation. And lastly, I do want to say this. One time, I've done a presentation with Ryan once before dealing with competency and mental health issues at the municipal level. And one person said something in response to it, well, he's he seems fairly cavalier, and we don't know that. Now?
You said we're standing.
Okay.
I'm standing.
Okay. So in any event, I do want to emphasize to you that, I do have a very irreverent sense of humor, but, my mother's mother was bipolar, and she actually committed suicide before I was even born. And I can personally tell you that it has affected our lives, affected my mom, the way that she interacted with people. It has affected the way I was raised. It is something that is very important to me. Mental health issues are very important, and I feel them very deeply. So please don't misunderstand if I maybe take a little bit of a light attitude. My marching orders, I believe our marching orders, were to try and be, to make this at least engaging, and so that's what we're going to try and do. So with that...
Drums, please!
All righty then. How y'all doing out there? Oh, come on now. Who's still alive out there? Check your neighbors, check your pulse. Glad to see you here. Okay, listen, first of all, I want to make my own disclaimer. First disclaimer is that I was hoping maybe with a picture of the team up, maybe Lennon and McCartney. Didn't get that. Okay, I can accept that.
Or the Finn brothers.
Or the Finn brothers. But I have to say this. What I'm happiest of is that it's better to be the DJ and Jazzy Jeff, I guess, than to be Will and Jada. So at this point, we'll take it as it is. And
Get his name out your mouth.
Yeah, and we will roll with it. So listen, we're going to start off with SB 2479, the JCMH Omnibus Bill. And we're going to break it into pieces. He and I are going to throw this back and forth. We're going to talk about 5 different pieces of the bill. I want to start off by talking to you about the provisions that amend Section 573.012 of the Health and Safety Code. So let me ask you, how many of you have ever paused to take inventory to truly appreciate how much your life has been changed by technology in the last 5 to 10 years? How many of you are still like, anybody out there still amazed that I don't have to go to the bank? I can do all of my banking on my phone. And how many of you have also recognized that sometimes it takes a while for the law to catch up with, I guess, where the rest of the world is, or sometimes it feels like that. Now, for those of you who maybe aren't that involved in criminal law, let me just tell you, the Texas legislature's approach to updating the Code of Criminal Procedure is not what I would call that technologically progressive. For those of you who are criminal law practitioners, you might recall that it's only been in the last 10 years that we got rid of the language that talked about sending warrants via telegraphs, all right? So, when I tell you that Section 573 is being changed so that we can change the way that we deal with requesting certain types of emergency apprehension orders, understand that we put this into the context of understanding that the entire world is changing in front of our very eyes, and this is a good example of the type of change. So previously, under the former law, the real issue was that it only allowed physicians to electronically request a warrant from a judge for an emergency mental health detention under this specific section. And in less populated areas, that was a problem. I'd like to see a show of hands. Where are my rural Texans? Where are you, rural Texans? I can feel your presence. And so the fact of the matter is you might be able to find a magistrate 24/7, 365 in Harris County if they'll pick up the phone. But the reality is it's tough. It's tough. In wide open spaces where many of us grew up, it's not that they're not willing to help you. It's a question of can you find them. So that's the reason why SB 2479 was introduced. This amendment permits licensed medical health professionals with advanced training and education to electronically make the request, and such applications for these emergency detention warrants by those other than physicians, they really are limited. It's limited to those situations where the subject of the application is currently receiving care at a hospital or a facility that is operated by a mental health authority. All right. Now, the next one I want to talk to you about is one that has been very near and dear to my heart, as well as to many other folks out there who have been involved in this issue. And it has to do with Article 1622 of the Code of Criminal Procedure. And to kind of put this into context, the issue that we're dealing with is something that has been a subject of debate. Every now and then the Texas legislature passes what's supposed to be a non-substantive cleanup bill. And it's supposed to be non-substantive in the sense that it's not supposed to change the law. But in this case, many of us believe that it actually did, and it did it in a way that did not serve the interests of many individuals who end up coming to our jails. So let me talk to you about kind of what the issue was. The issue is specifically the authority of a magistrate to make the determination that a 1622 assessment needs to occur, and in what type of cases are they allowed to do that. Now, prior to 2017, I want to make it clear, I think a lot of people act like 1622, it didn't exist prior to 2017. I think that our awareness of 1622 increased after the Sandra Bland Act. But the reality is it's been around for a long time, and there was never any type of restriction on when the magistrate could order it. Well, after the changes that occurred in 2017, it stated that it could only be ordered in cases involving a Class B or higher. And the problem for those of us who have worked at the jail and for those of us in law enforcement is, honestly, if someone's in distress and if someone needs help, it shouldn't matter what they're arrested for or what the initial determination is for probable cause. And that really was the issue. And so what this bill does is it really does, I think it's a pretty valuable compromise. And the language was a compromise because there was a conflict. The conflict is that there were a lot of folks that were concerned that because of the number of Class C misdemeanors in the state of Texas, that it could, quote, crush the system, and we already have limited resources and we're struggling with the resources that we have. However, let's be clear. I'm willing to ask you, without asking you to raise your hand, many of us in this room have probably received citations and have been accused of Class C misdemeanors. But I'm also willing to bet you that most people in this room have not been arrested, taken to jail, or repeatedly arrested and taken to jail for Class C misdemeanors. And what we know is that the research tells us that those individuals that are repeatedly arrested on such charges are sometimes the people that are most in need of help and intervention. So what this bill does is it basically strikes a compromise. And I want to acknowledge the JCMH staff because they are the ones that came up with the language that really kind of, I would say, address the conflicting perspectives of the parties, is it strikes a balance. It gets rid of the language that says that it has to be for Class B or higher, but it also does not create a mandate. It says that on Class C misdemeanor charges that the magistrate has the discretion to do it, but it doesn't mean that they necessarily have to. And I think that, I think that's going to go a long way for those of us who see individuals down at the jail. All right. So far, so good?
Sure.
All right. Here we go, part 3.
Okay, so I can attest to the fact that this is definitely a very near and dear issue to Ryan's heart. Like, I would talk to him and he'd be like, hey, what's up? And he'll be like, Article 1622, man. Article 1622. I'm like, what are you talking about? Like, I had no idea that this existed. I'm here to talk about one of the changes that happened with, one of the big changes here too was Court of Criminal Appeals Article 1703 was sort of fixed to correct an inconsistency that was going on that sort of allowed non-violent offenders who are suffering from mental health issues to get out on a personal bond because there was some concern. There was a bill passed or a law passed that basically prevented personal bonds, and so they had to sort of carve out this exception, and that's what they did. This basically, it just sort of corrects this inconsistency and says a defendant or someone who's accused of a crime may not be released on a personal bond if there is an offense involving violence, it commits an offense while on bond for a crime of violence. And the crime of violence that they talk about, or they specifically list them, are any felony, assault, deadly conduct, terroristic threat, or disorderly conduct involving a firearm. So again, this goes back to what Ryan was mentioning about the balance between the two different perspectives. On the one hand, we want to make sure that we can get the services and get the intervention for folks that need it, but we also want to try and balance that against making sure that people stay safe. So by creating this, the legislature has sort of said, yes, on crimes of violence, we're very concerned about making sure we keep an eye on people and keep people in custody who've committed a crime of violence, but they also acknowledge that, hey, look, there's several exceptions, including the exception for mental health bonds for nonviolent offenders. There's also Article 17032 says, look, if it's a nonviolent offense and there's a showing of mental illness after an examination and report establishing there's the existence of mental illness and the person has committed a crime because of that mental illness, and there is community-based treatment, the report indicates that community-based treatment is going to work, and there's that showing there. And there's also a risk assessment to show that the person is not necessarily a risk to others. If they can get out on a personal bond, they go ahead and allow that. And they also put as a condition of the bond, outpatient treatment. So there are some others, so just to be clear, there are other exceptions that are in there. They're not necessarily mental health related too. They sort of acknowledge, look, for out-of-county warrants where you don't go get the person, if you don't go get the person with a certain amount of time, then they get a personal bond. Also, 17033, arrest without a warrant, and there's no probable cause determination. You have a certain amount of time to basically give them a bond, and if you don't, then they have to be released. And then, of course, the classic one is when the state's not ready for trial. So, number 4, the other thing I want to mention is something that Ryan, I believe, just mentioned too, is that, look, this tweaks the section, Health and Safety Code section 573021 sort of tweaks the transportation and applying, the statutes dealing with transportation applying for emergency mental health services. It specifically does away with this idea that the police officer has to sit and wait. They can now sort of hand off the person to the facility and they don't have to stay there. And it also, as Ryan also mentioned, it allows licensed mental health professionals to submit the application for services. It used to require a physician. Now now you don't have to wait around for the physician to be there. So it should speed things up. That's sort of the idea. And then lastly, part 5 of 5, too, this is just sort of an acknowledgement where a defendant has actually been, where there's an order for involuntary medication because the medication is medically necessary for their mental health issue. That order can also necessarily authorizes blood tests and a blood draw for determining what kind of medication they need, what's going on with their blood work to see how to best prescribe that medication. So that's an interesting thing. I don't know whether this is going to run into problems with the Fourth Amendment or not, but that's maybe something you can see arguments being raised about it. But in the end, if there's already the point where you're getting involuntary medication, that order now will allow judges to go ahead and do a blood draw to try and make sure that the medication that they're giving to the person is going to be the right medication. So a couple of things, too, I wanted to sort of mention about proposals that the Commission on Mental Health suggested, and no one was hurt in this accident. Okay, I just want to mention that. Okay, they all walked away fine. They are not considering ever doing archery ever, but they are, obviously everyone was fine. So, but this is what I'm going to talk about is these cases, these were proposals that were suggested and ultimately didn't make it and may make it next time. Okay, one, there was a provision that would authorize police to secure firearms in emergency detention under a warrant. That didn't make it. This is probably coming up against sort of the opposition to sort of red flag laws that you would see. There was an effort to limit inpatient competency restoration for nonviolent misdemeanors. So for nonviolent folks, you couldn't put them in inpatient. They were going to try and fix that. That didn't make it as well. Procedures, there was an effort to create procedures for deterioration after competency restoration. Sometimes when people have been determined incompetent and we wait to see if they get treatment and they can be restored to competency, sometimes that whole process can lead to a deterioration. So what do you do, right? Also, there was an effort to sort of work in some credit for participation in outpatient competency restoration. That was also didn't make it. And then lastly, dismissal of Class C when the defendant isn't competent. Just saying, well, instead of going through the whole competency process, we should just say, look, if he's not competent, we're just going to waive the Class C offense. So those are the ones that didn't make it. And and lastly, a deferral of arrest for nonviolent offense as well was also a suggestion. It didn't make it. So
I'm not just a dance, am I?
you can. For inspiration. Come on.
I have to tell you,
Get into the groove.
I'm just surprised we don't have like pictures of Hugh Grant. We're going to be talking about grants now, not Hugh Grant. I want to tell you that first of all, that in terms of the first bill we talked about, SB 2479, there were a lot of things in that proposal that didn't ultimately make it over the finish line. I think that bill started off as being like, I don't know, it was like maybe 21 pages. I think it kind of got whittled down to about 4 or 5. This next one, though, for me, it's just a little bit intimidating because when we're talking about big money, we're also often talking about big and complicated bills. So SB 30, I think, is a very exciting bill, but I will also tell you, for those of us who maybe aren't the most authoritative on matters of governmental finance, it took a little bit of work to kind of cut through this to kind of distill it down to its essence. This was a bill that when it got introduced was 84 pages long, but by the time it made it through the legislative process, it was 120 pages long. Why is that? Because everyone has things that they want to get paid for, and we only, thank goodness, only have session in Texas every 2 years. So this bill, just to give you a little bit of background, each legislative session, you have state agencies, and these state agencies project the cost of what it's going to do their jobs. And they report those numbers, and it's going to be used for budgetary purposes. And then this information, it gets combined with like biennial estimates of revenue, how much money do we think is actually coming in. And then you end up having a General Appropriations Act. And from this General Appropriations Act, by the way, are you still awake? If you are, give yourself 5 extra points. Stay with me. I promise it will get better. All right, but here's the deal. The question is, once you have this General Appropriations Act, how much money can you get put into supplemental acts to advance things that you care about? And what I will tell you is that if you are in this room, I guarantee you, you care about issues pertaining to mental health, all right? And that's what this bill is about. Ultimately, these supplemental appropriations for mental health, this is a big deal. We're talking about $100 million, okay? And in layman's terms, this is really about time. It's not only just about time, it's really about what I will call, and this sounds like a very 2001 political type of statement, but this is what we call shovel-ready projects. Because the opportunity for construction and the opportunity to create new facilities to advance mental health interest is substantial. So this has to do with $100 million in a supplemental bill that's going to be used for county collaboratives. And we're talking about construction of jail diversion facilities, step-down facilities, permanent supportive housing, crisis stabilization units, crisis respite units. One of the things you can't use it for office space, but if you look at all the things that you can use it for, it's something that you can really get excited about. Now, it involves a match program. And you end up having a situation where it has to do with your there's like a match of 25% if the collaborative includes a county with a population of less than 100,000. It's 50% if the collaborative includes a county with a population of at least 100,000, but less than 250,000. Or it's 100% of the grant amount if the collaborative includes a county with a population of 250,000 or more. I have to tell you, there's nothing like the 4 o'clock hour to talk about the bracketing of legislation with an audience that's tired. Give yourself a round of applause just for making it through that one segment. Thank you. I'm serious. Go ahead and do it. Pinch yourself. You're still here. All right, now let's go ahead and talk about the next component here. There are a couple of related things, and I was glad to see that on the agenda for this summit, we're going to have more conversations about the status of mental health amongst our youth in this country, because we definitely have serious reasons to be concerned. Let me give you a factoid that really, really saddened me. The Center for Disease Control reports that only about 20% of children with mental, emotional, or behavioral disorders receive care from any type of specialized mental health care provider. All right? Now, 20%. I don't know why they couldn't just flip it and say 80% don't, okay? Maybe that's the way that has the most impact. But one of the things about SB 26 is that this is an effort to try to address this specific problem. It adds a new provision to the Health and Safety Code that tasks the Health and Human Service Commission to establish grant programs that provide support for certain types of eligible entities for community-based initiatives that are really designed to promote, identification of mental health issues and to improve access to families that presently do not have access, to children and to families. So that's very, very important. It has a lot of administrative stuff in there that I'll spare all of us from, but it does. I mean, it requires the HHSC Executive Commissioner by rule to establish application and eligibility requirements for the entities that are going to be awarded these monies. And it does list a whole slew of different types of groups, including municipalities that are eligible for this. So that is SB 26. All right, so let us, and then of course one more thing, and I'll talk a little bit about this. I was also glad to see in the same vein, you've got SB 1677. One of the things that I think is just a real dominant theme, it's not always as obvious, is these issues having to do with the urban-rural divide. The fact is that the amount of resources and how they're allocated in the state, I think it's ironic. I know people who typically are from rural Texas think that everyone in the metropolitan areas, they got it going on. And of course, the people who are in the metropolitan areas can tell them, yeah, that's not really how it is. But it doesn't change the fact that that historically there has not been adequate resources in terms of grants in rural Texas. And so that's what SB 1677 is focused on, is by providing rural grant programs for regional behavioral health centers and for jail diversion centers. All right, where are we?
I did my best, but I guess my best wasn't good enough. 'Cause here we are back where we were before. Seems nothing ever changes.
We're back to being strangers. What? It's James Ingram.
That's pretty good.
Yeah.
I like it.
Anyway, so
I like it.
So,
I like it. It'll work.
I actually cited to that song in a case once. So, in any event, one of the things I always like to do when we do presentations like this, we like to sort of highlight some other things that you just want to draw your attention to without going into great detail. And so, Ryan has suggested 3 things for 3 different bills to also draw to your, just so that you know that they're out there. Just some other bills to consider. House Bill 446. This just amends statutes to get rid of and replace the phrase mental retardation with intellectual disability. As many of you are,
Yeah, about time.
yeah, I mean, you could see it developing in the law. They've kind of gone ahead and clarified that. And so it does it across many different statutes. There's also, when I'm talking about juvenile law, it specifically does that. Also, HB 2059. This basically provides grants for training for mental health first aid and expands the eligibility for these individuals to participate in the program, including youth, first responders, judges, military service members, and veterans. And so it's just, grants and extra money so we can get greater participation in that program. And then, of course, in Senate Bill 63, this requires Health and Human Services and the Texas Veterans Commission to produce an instruction guide for families, family members and caregivers of veterans who have mental health issues. So just a couple of things to keep in mind, just to look at. And so with that,
It's hard to wake up when the shades have been pulled shut. This house is haunted, it's so pathetic, it makes no sense at all.
so I kind of want, my son used to play Linkin Park to me, and I thought that would really be too loud, so I didn't want to give you that. So I went with something a little bit more metal, some more dad rock on that one. But basically, I'm going to talk about, just give you a general overview of Senate Bill 1585, which deals with juveniles with children with mental illness and intellectual disability in juvenile court. And basically, the big thing you want to say is that what this does, they fixed Chapter 55. That was sort of the goal, was to try and get everything together and make sure that Chapter 55 in the Family Code is sort of the one-stop place to go if you're dealing with a juvenile with intellectual disability or mental health issues. They restructured, basically, they update the terminology and they add a whole section dealing with definitions that appeared elsewhere. So they're not a foreign definition, they're not definitions you wouldn't be used to, but they're moved over into this one place so that they now clearly apply in this circumstance. One of the things I thought was really, really interesting, and I think you'll all agree, is that they have moved away from the term commitment to court-ordered inpatient and outpatient treatment. So it's sort of one of the way I was just talking to Hema earlier, and she was just saying it sort of turns the page away from the idea of treating kids as adults in the juvenile justice system. Instead of looking at commitment is kind of a loaded term. It's kind of confusing when you're talking about juvenile law. Now it's just very clear, it's broadening. We're talking about getting court-ordered services for folks, inpatient, outpatient, residential, those kinds of things. Also, they specifically go out of their way to provide guidance for evaluators to identify minors with mental health issues and how you can evaluate and help them evaluate them and help get them the treatment that they would need. Just to make sure that you understand the structure, this is the part that makes me the most nervous about teaching about this, because I'll be candid with you. I don't know how familiar you are with the legislative process, but it doesn't always work the way that they plan it, And so the idea that they fixed this chapter and they've sort of put it all together in one place, the devil is going to be in the details. Sure, there's the overview is all of this stuff is stuff that should be familiar to you. It's stuff that you're used to. It's just that now we all know where it is. We tried to get rid of conflicts, but you know that there's going to be terms that were ported over or rephrased that are going to maybe create different sections or meanings. But I did want to sort of at least emphasize the way that the bill was structured and the way that it was sort of put together. Subchapter A now is going to be your definitions. It's going to give you all sorts of important definitions of the terms that are relevant, like I said, are brought over from other sections. Subchapter B addresses court order of mental health services, sort of explains what you need to show or what needs to be shown in order to get those things. Subchapter C deals with a situation where the child is unfit to proceed because of mental illness, and so we should take them out of the system. Also, on the same vein, subchapter D is we're going to evaluate the child for lack of responsibility because of mental illness. And then lastly, a brand new chapter, even though it's a brand new subchapter, it still, like I said, is sort of bringing together a bunch of ideas that already existed. Just sort of, this is the place to go when you're talking about residential treatment for juveniles. So the first thing they did was they updated terminology, gave different definitions. Like I had mentioned earlier, intellectual disability now instead of mental retardation. We try to make sure that that's what the common term is. Also, like I mentioned as well, court ordered mental health services rather than commitment. We're moving away from the idea of locking children up or juveniles up, and now we're looking at, well, we want to try and move them where they need to go, and we need sometimes outpatient, sometimes inpatient. And then, of course, some of the other definitions here too. Chapter 55, subchapter A is the general provisions here. 5501 gives you your definitions. And as I mentioned, it adopts the relevant definitions from the Texas Health and Safety Code, as well as other different codes, but specifically from there. So when it gets to the court-ordered inpatient and outpatient treatment here, basically in order to establish this, both situations you have to have probable cause to believe the child has a mental illness. The court shall temporarily stay the proceedings and order an examination if there is probable cause. And this is something just to say too, that sort of while we're talking about this, one thing I did note when I was looking at this is they now have set out specifically and defined what the standard of care is. And I wanted to read this for you because I thought this would be something that this audience would appreciate. Now, the focus here is treatment ordered under this subchapter for a child with mental illness must focus on the stabilization of the child's mental illness and on meeting the child's psychiatric needs in the least restrictive appropriate setting. So it does a couple of things. Like I said, it's moving away from sort of a punitive attitude towards children and sort of saying, well, now we're going to look at, well, what is the best way that we can help get this child the help it needs, and let's emphasize and prioritize doing it in the least restrictive way possible. So that's sort of the guiding principle for that. And so when you're looking for inpatient and outpatient treatment, that's the thing that courts are going to be looking at for that. Section 5504 specifically defines what goes into a forensic mental examination. Like I said, probable cause that the defendant is unfit to proceed because of mental issues or mental health issues or intellectual disability. It also specifically goes in and says what your expert qualifications have to be in order for the person to give that report. So that's where you find that information. For temporary inpatient and outpatient treatment, basically this is a 5505 that gives you the criteria for the court-ordered mental health services for a child. There's got to be a showing by clear and convincing evidence for this treatment. And basically you look for exactly what you would expect, everything that you would expect. And I'm not going to do this justice because I don't have enough space on this slide. And you're also going to be in breakouts with folks with far more accomplished experts than me than you can ask to get into the nitty-gritty details about this. But basically, you're looking to see that balance I mentioned earlier. Are they likely to cause harm? Are they suffering severe distress? Are they suffering a mental illness? Are they deteriorating from a mental illness? What is the best possible type of treatment for that? Or what are the facts that you would use to establish to say inpatient is better than outpatient for this person? Why we need to do inpatient versus outpatient? And then temporary outpatient is going to be, you have to also show that the services are available. You would now have to show that there's a severe mental instability or mental illness that is likely to deteriorate. And so that is why we have to try and make sure that we do this type of treatment. Extended inpatient and outpatient treatment, basically you extended inpatient treatment, you have to also show, in addition to everything you've shown for temporary treatment, the condition is going to continue for more than 90 days. So that's why you have to extend it. And also that the person has received, or the child has received inpatient treatment for 60 consecutive days during the preceding year, and this is why we still need to continue. Extended outpatient is going to be very similar, sort of a corollary to that. The condition is going to continue for more than 90 days, and of course, they received in or outpatient treatment for the last 60 days. So residential treatment, also there's guidance on how to or when you are going to do residential treatment here. 5506 sort of sets this out. Residential intellectual disability services. You can't order this unless, you can't order resident, that's sort of a key thing, unless these things are shown. There's a substantial risk of harm. The person is unable to care for themselves. The child is unable to care for themselves. They can't adequately be treated in a less restrictive setting. The residential provides the services that are necessary. Residential setting provides those services, and an interdisciplinary team recommends it. So let me go back and just say that. So basically, like I said, you can see in the way that this is created how the emphasis is really on trying to make sure we tailor these services instead of doing a one-size-fits-all, to making sure we give the child what the services they need. Also, with regard to residential services, for residential intellectual disability services, you can't order unless there's a substantial risk of harm. They're unable to care for themselves. They can't be adequately treated in a less restrictive setting. And the resident provides the services, and the interdisciplinary team recommends. So it's basically the same basic thing, but for a different issue. So they also, the section also gives guidance for evaluators. They basically say, look, the section of the code, the legislature added section 5531D. The expert shall consider the capacity to do these things. Appreciate the allegations against the child. We have to evaluate whether the child can appreciate the allegations against them, whether or not they can appreciate the range and nature of the allowable dispositions. I think that actually cuts against the idea that we're treating these children as children instead of adults. That is a very, very big ask for anyone facing the criminal justice system, but that's one of the things they're going to be evaluating, right? Understanding the roles of participants, or maybe it does work the other way, now that I think about it. Understanding the roles of the participants and the lawyers, what the lawyer is supposed to do, what's the judge supposed to do. Displays, whether or not the child can display appropriate behavior, courtroom behavior, whether they can testify relevantly, whether they can engage with counsel in a reasonable and rational manner. Those kinds of things are what you look for, and you issue a report to determine this. Also, the report has to give an opinion on the child's fitness to proceed, and or explain why the expert can't give an evaluation on the fitness to proceed. They have to include the child's history, the child's developmental history, functional abilities related to standing trial, assess the likelihood the child can be remediated or restored, because that's the emphasis, to try and do that. Also assess if the child can be treated in an alternative setting, and also recommend other types of interventions. So with that, I will turn it back over to you for Youth Intervention and Diversion Act.
All right. Thank you very much. I want to kind of get a gauge on the room here. I want to figure out who all is in the audience. Let me see your hands. How many county commissioners do we have out there? We got any county commissioners? Any county commissioners? Someone maybe half raising there. Raise your hand high and proud now. Where are you? Okay, got a county commissioner. Very good. How about city council members? We got any city council members present? Any mayors? Okay. How about, this is the way I used to teach this in government, the constitutional county judge, the mayor of the county. How many constitutional county judges? Got any constitutional county judges? See a couple of hands back there. How about, back of the room, how about sheriffs? Sheriffs, law enforcement, police officers. Yep. All right. Very, very good. Now, let me keep going with this. How many folks do I have that, how many district judges do we have in this room? District judges? District judges, all right. County judges? Justices of the peace? Municipal judges? All right, appellate judges. I'm just giving you all an opportunity to raise your hand and participate here on the front here. I don't want you to feel left out, okay? So, all right, now let me ask you this. How many folks do I have in the room that are advocates? Where are my advocates? Criminal defense lawyers, make your presence known. Where are you? Okay, you're out there? Okay, how about mental health policy advocates? If you are here, mental health advocates? All right, because what I'm going to talk to you about, all right, listen, I'm not going to leave Professor Shannon out. Professor Shannon, I told you I was going to save this quick story. The last time I got convinced by the JCMH to Garfunkel on one of these presentations. I decided that I was asked to team up with Professor Shannon, and I said I would be honored to. And it's amazing what you can learn about someone in the middle of a pandemic, okay? So do you remember this, Brian? You and I had to do this on Zoom, which is always awkward because it's like we're both at our homes talking to glass screens and there's no one there, and we're trying to act like, oh yes, we're having a jovial time here talking to the glass screens. And I share this little story about my daughter who was attending Joslyn Elementary School, which is only like 5 blocks from my house, but she can't be there because of the pandemic, and how weird it was that I'm up here doing this and my wife's a counselor and she's downstairs counseling, and my kid is experiencing his first year in high school and he's in the back of the house, and my daughter is downstairs playing cyber truancy. Okay, that's what I said. And the funny thing is, Professor Shannon goes, "Did you just say Joslyn Elementary?" And I said, yes, I did. And he said, that's where I went to school. All right. Now, that flummoxed me for a second during the presentation. And I later told my daughter, I said, get this. I said, this professor I know, he went to Jocelyn. And she said, whoa, 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 whoa. You're telling me that if I finish school here, I can be a law professor? And I said, sure, we can get you on that track. Anyway, just wanted to share that story. All right. So the last time that we Garfunkeled, we had this opportunity to kind of try to figure out who's in the room, who's doing what, and how we put all these issues together. Now, Judge Newell has just spoken to you about this massive overhaul of Chapter 55. And I don't care what area of the law, if you've ever been involved in the law or you've ever been involved in public policy, you know that there is almost nothing as terrifying as an overhaul and the unintended consequences of an overhaul or adding things. And one of the things that I really want to talk to you about, which is the thrust of HB 3186, is that quite often when there's collateral damage or inadvertent consequences of legislative changes, we do not always go back and make any effort to make it right. And that's the reason why we're closing with HB 3186. I will tell you that HB 3186 is the most significant piece of legislation that most of you are unaware of, okay? Because it really goes back to some deep-seated legal issues. Now, I want to see another quick Ryan poll here. Where are my UT Law School graduates? If you are a graduate from the University of Texas Law School, raise your hand, all right? Did you go to UT?
I did.
Okay, all right.
I got all the way here with no help from career services.
All right, okay, well. SMU, if you're listening, you're not getting much more of an endorsement than this guy just gave for his law school. All right, so what do you mean you don't want to do transactional work? Do you know where you're going to law school? Well, yes, I do. All right, okay, so let me, the reason I ask is because I want to tell you a little bit of history to put this into context. So when I finished clerking at the Court of Criminal Appeals and I was like the baby young lawyer at TMCEC, I was told by my boss, Hope Lockridge, that one of my jobs would be that I would be working with Professor Dawson at the UT Law School and that I should make myself available at all times to assist him in whatever legislative projects he was involved in because it would be good for me and it would hopefully help us improve the system. And my opportunity to work with Professor Dawson for 4 years really was like an extra bonus round of law school. I cannot tell you how much of an impact Professor Dawson had on me and a lot of other young lawyers trying to understand how policy is made and how the game is played, okay? And sometimes how the game can go adrift. One of the things that Professor Dawson told me when I started working with municipal courts in the late 1990s is that the train had already left the station and that there was something that could in the long term have unintended bad consequences. And let me talk to you about what that is. It has a little to do with this photograph here. It has to do with the fact that if you had a child who was a teenager, who was to steal that car you see in the background, that under Title III of the Family Code, that teenager could be accused of, delinquent conduct. And we have a specialized series of procedures because we recognize inherently that children are different and that we would handle them through this civil system. However, if that same child were to steal this toy car that you see on the screen, that child would be adjudicated as a criminal. That child would be adjudicated without the assistance of counsel. That child would be adjudicated in a court process which is designed and built for rapid adjudication. And there's something that the professor recognized even back in the late 1990s was wrong about that. And he explained to me, and for those of you, I guess I should ask, do I have any juvenile law practitioners? Any juvenile law practitioners? If you look in his treatise and you look in his writing, he has a whole section on what he calls the shadow courts, about municipal and justice courts. And he hints to it, and when he knew that he was ill and sick and not likely to live much longer, he actually told me that he hoped that one day Texas would get around to fixing this particular issue or try to address it. Because there are massive issues of inequity. So let me go back. You've got two types of subject matter in juvenile court. You got delinquent conduct, which I would describe to you folks that are not lawyers would be like things that if you or I did it as adults, we could potentially end up going to jail, sentenced to jail or prison, all right? And then you've got conduct indicating a need for supervision, which I would like to describe as being like just not a good idea, okay? Stuff like huffing paint, not a good idea, okay? Running away from home, not a good idea. And in Texas, we decided to add one more component to that, everything that's a Class C misdemeanor with the exception of traffic, okay? Now, the reason why that is important is that theoretically, every time a kid commits a Class C misdemeanor with the exception of a traffic offense, that case should be eligible to be adjudicated through Title III and Chapter 55 of the Family Code. But it doesn't happen. And it hasn't happened for a very, very long time. I have a list of books that I would like to write that I know deep in my heart I'm never going to write. Like I've got a coffee table book on 20th century Texas crime, and I've got some law review articles too. I've written 3 law review articles, but here's one that I don't think I'm ever going to get to, but I would like to, which would be like, whatever happened to chins? The whole conduct indicating the need for supervision. By the way, if you are not a Texas law practitioner, you might have been taught that that was sins or chins, child in need of supervision. I think in Texas, the whole notion of sins and chins, well, we ended up going with conduct indicating a need for supervision. Here's the thing. The number of chins cases or conduct indicating need for supervision petitions has steadily decreased and decreased and decreased in Texas juvenile courts. You can go look at the OCA data. And if you want to know what the rapid accelerant of that was, it was when in 1987 we changed the law that said that all those cases can be rapidly adjudicated through municipal and justice courts. And for those of you who are unfamiliar with municipal and justice courts, these are criminal courts that use criminal procedures that have criminal consequences that involve the imposition of fines. So what I'm telling you is that if your child were to steal that car, that child would never be fined, okay, would not have a criminal conviction, but if your child stole that toy car, they could. And that has been very disturbing to many people for the last 15 or 20 years. It's been increasingly disturbing. So HB 3186 is the third attempt of the Texas Judicial Council to try to make this situation fairer. And I'm happy to say that I guess the third time was the charm. And I will tell you that I know for a fact that Professor Dawson would be very, very happy to see that this bill finally passed. So you've had this long-standing disconnect. And I will tell you that I think one of the reasons why this bill passed this time and didn't pass in past sessions is, one, it's a major piece of legislation. It's like, it's like building a big, it's a whole new subchapter in Chapter 45 of the Code of Criminal Procedure. And for those of you who are not that familiar with municipal and justice courts, but maybe are familiar with criminal courts, similar but not the same is a pretty good descriptor. You've got these concepts that are like concepts you know in county and district court, but they're just a little bit different. And it's trying to account for how can you make a system work that handles so many kids. Let me put this into context. Excluding the 130,000 traffic cases, Class C misdemeanors, that I think may have involved some of your children, okay? I am talking to you about 50 to 80,000 cases a year that were eligible to have been filed as chins petitions. And what this system does is, I think that in the last 2 versions to try to pass it, there was a focus on equity and fairness. And I think what might have made the difference this time was that the focus still included the equity and the fairness component, but it also was broadened to include identification and intervention of children who really need help. Children that don't need punishment, children that don't need criminal records, children that don't need to be fined, but children that need referrals, children that need someone to intervene. And sadly, I will tell you that it was events like the events in Uvalde that I think really did make everyone figure out that there's no way with limited resources that we can get this done if we're not using, the municipal and justice courts are like 60% of the Texas judicial system. If you're not leveraging all of your assets strategically, it is very, very difficult to bring about meaningful change. So this was a re-engineered third attempt, and HB 3186 really does not only address the equity and the fairness issues that had been the focus of the bill the last 2 go-arounds, but it also really, really gets serious about reallocating resources and making sure that early identification and intervention is part of the solution. And I want to give a big shout out to everyone on the Texas Judicial Council, all of the nonprofits, all the local governments that helped get this bill over the finish line. But I also want to give a big shout out to Megan Lavoie, because I have to tell you that Megan and her team did a fantastic job of taking this issue. A lot of people would have said, well, we tried it twice, it's time to quit. She and the Chief Justice were very clear on the fact that we were not going to quit, that we were going to go again. And I was asked if I would volunteer to serve on the work group, and I said, I will do this one more time. I'll do it a third time, but after this, I'm out. Because I'm telling you, it's one of those things, and y'all know how this goes when you're trying to get stuff done. You try, you come up short, you try, you come up short. At a certain point, you wonder, man, maybe this just isn't the right way to go, all right? So HB 3186 really does, it makes some substantial changes in terms of aligning those court practices that we have traditionally associated with our Title III courts, our Chapter 55 courts, our juvenile courts, our juvenile probation departments, by creating a mandatory system of diversion. All right, so now that you understand the car, let's go ahead and I want to kind of make sure that you're all able to leave here knowing what you need to know, regardless of what your walk of life is. First of all, let me just tell you briefly what the applicability of this chapter is. We are talking about offenses that could have been filed as Chin's petitions or conduct indicating need for supervision cases, but weren't. They're being filed as Class C misdemeanors. And so in other words, it has no application to traffic, because traffic offenses can never be filed under Title III of the Family Code. All right, now, a couple of things you also need to know is that one of the things that judges felt strongly about was there's plenty of stuff in the municipal and justice court universe that works just fine. There are things that Professor Dawson spent years trying to engineer to get right, and no one was thinking this is a good opportunity to hit the reset button and start over. So the whole idea was, how can we recycle things that are working and try to improve upon them? And that included making sure that, first of all, juvenile transfer, unaffected, okay? One of the things that I think had to have been done to make this bill pass was the question was eligibility. This is still Texas, and I don't care if it's a Class C misdemeanor. There are certain people that are tough on crime that think that diverting kids, even though maybe in a perfect world they wouldn't even be in a criminal court, looks soft. So in order to pass this bill, there were some changes to what I call the 4 touchstones. First of all, they're eligible for diversion once every 365 days. It's not a revolving door. They're not eligible for diversion if they've had an unsuccessful diversion. That's the second touchstone. The third touchstone is that, hey, you're not eligible for diversion if the prosecutor objects. Now, this is something that's a little different about municipal and justice courts, too. The volume is so heavy, you're allowed to direct file. You don't have to have a prosecutor review a case necessarily to get it on the assembly line. But it was believed that it's still important. The case belongs to the state, potentially. They need to have the ability to veto. That's the third touchstone. And then the fourth one is that you can't divert a child without an agreement between the child and the child's parent, okay? There has to be an agreement. And that's where this thing kind of takes on a civil nuance, because this is done in the form of a diversion agreement, which is basically a civil contract, okay? All right, so that's the application. The definitions, the only one I think for this audience that I want to hit home, there's a lot of specific definitions, and y'all know how this works. You've set up the law by giving definitions. But I want to talk to you about the definition of a service provider, because I think, let me ask this, like, where are the folks in this room? How many LMHAs do I have? Folks associated with our LMHAs. This is where I think LMHAs have new opportunities that did not exist prior to this legislation. Okay, so a service provider under this act is defined as a governmental agency, a political subdivision, a local government, including a school district, or an open enrollment charter school, a nonprofit organization, or other entities that provide services to children or families. Now, that is critical. That now completely opens the way for a whole lot of folks to get involved in ways that prior to this bill, they may not have been able to get involved. I will explain more in just a second. Okay, next thing I want to talk to you about is the objectives, because I think that there are 4 objectives. They're important. Want to hit them really quick. First of all, the objectives of this new subchapter is to reduce recidivism and the occurrence of problem behaviors through interventions without having to criminally adjudicate children in justice and municipal courts. That's the first objective. The second objective, and this is one that I know is going to be near and dear to the heart of folks in this room, is to identify at-risk youth, including youth with mental health needs, substance use disorders, or intellectual and developmental disabilities, and where appropriate, make referral to early youth and intervention services under subchapter D, chapter 264 of the Family Code. This new subchapter authorizes diversions of children that are charged with certain offenses that are punishable by the imposition of a fine, and it has to emphasize accountability and responsibility, not just of the child, but of the child's parent or guardian. Okay, that's the third objective. And then lastly, and I think this is the part that I'm the most excited about, is that it increases collaboration between governmental, educational, and nonprofit organizations by devising both local and regional diversion strategies. Okay, so let me just tell you, the work group, the criticism that I hear from my constituents all the time after legislative session is, why is it that it feels like every piece of legislation was written for Austin, Houston, San Antonio, and Dallas? What about rural Texas? Raise your hand if you've ever felt that way after reading a piece of legislation. So our work group came up with a test that we called the Spearman, Texas test. How many of you have ever vacationed in Spearman, Texas? Have you ever been to Hansford County? Did you even know that you could drive 100 miles north of Amarillo and still be in Texas? Did you know that if you are the municipal judge in Spearman, Texas, you might go shop at Walmart in Liberal, Kansas, but you don't want to admit to your friends that you're going to any place that's called Liberal, okay? Now, we use this as a test. We know that if it's a place that Southwest Airlines flies to, we know y'all can get it done, okay? The question is, how do you do it on a shoestring? How can you do it on scale? How can you do it in Uvalde County? How can you do it in rural Texas? So that was the test that we came up with. And one of the ways, particularly like in the Panhandle, is by allowing greater opportunities for collaboration and the sharing of resources. Okay? Because there are a lot of things like juvenile case managers that they have in all the, the metropolitan municipal courts, but they don't have those in rural Texas. How can we create opportunities for more juvenile case managers? We're going to do it by reimagining what a juvenile case manager is. It doesn't just have to be a job. It can be a service provided by the boys club, the girls club, your local LMHA, your local junior college. In other words, the real limitation now is the creativity of local folks to get it done. All right, the mandate. This is the part typically, when you start talking about mandates, it's like, well, how many mandates? Here we go. What are they going to do to us this time? There is one mandate.
That's exactly what I think.
Is that how you feel when you read bills?
No.
Are you doing? Well, you know what? I will tell you, there are plenty of folks out there that
Sure.
after every session, it is just like trauma. Particularly if you're a county judge or a mayor or a county commissioner trying to figure, what do we have to pay for now? What do we have to do now? There's
unfunded mandates, yeah, absolutely.
Yeah, the mandate, the unfunded mandate on this one is pretty interesting. But here is the mandate. Every justice in municipal court, and this is what I want you to remember about this presentation, every justice in municipal court has to adopt a diversion plan by January the 1st, 2025. That's what you have to know, okay? Now, look, see all these issues? These are the issues that I'll be talking to municipal judges and JPs and probably a lot of county judges about for like the next year, all right? I just want to very quickly talk to you about 2 issues. The youth diversion plan. That is what you have to adopt by January the 1st of 2025. This bill goes into effect January 1st, 2024. You have to have adopted a plan by January 1st, 2025. You have to identify which diversion strategies you'll use. And guess what? A lot of these strategies are already being used by municipal and justice courts on the back end of convictions, on the back end of deferred dispositions. The only thing this bill says is we're going to allow these strategies to be used on the front end of the case to divert it from adjudication. So we're talking about mental health screenings, counseling, mentoring, mediation, substance abuse training, restitution, teen court programs, school programs. It's a very long list. Juvenile case managers are in there, job skills training. And it's not exclusive. Local governments can come up with additional diversion strategies. That's what they have to do. Now, back to the urban-rural divide in the last minute here. One of the things I also want to tell you is that this thing provides new opportunities for money, okay? One of the things that I think is most interesting about this is that it takes a lot of existing costs, okay? Are we supposed to call them reimbursement fees? I don't know. Never mind. I'll keep going. So here's the deal. The fact of the matter is these court costs, it reimagines them and expands their use. So it's not like we're creating a lot of new court costs. We're just saying that there are certain court costs that you can do more with, and we're going to allow the local governments to decide how they're going to use that money. One of the things I want to hit home is that when there was an overhaul of court costs a couple of years ago, it created a bottleneck for rural Texas where a lot of rural communities, rural counties, rural cities were being required to collect court costs that they had no way to spend, okay? There are municipal courts that don't see children, but they were still being required to collect specialized monies that pertain to children. So let me tell you what this bill does. One, it gives them greater opportunities to spend it, but then it also says, listen up, LMHAs, that in the event they can't spend it, they can use that money to support their local mental health authority. All right, so that's another thing that was added to this. Yes, and by the way, my organization has a conference going on in Tyler right now. I'm going to leave this place and drive to Tyler as soon as I'm done. It's going to be great. Sorry you can't all go with me. But I'm going to tell you this. We had a clerks event yesterday, and a number of cities are already wanting to know how do they do that. There really are going to be some places that will be looking to use the money that's being collected to support LMHAs as part of the diversion plan. So that's how it rediverts that. And then in closing here, this is the last thing I want to talk to you about is we know that under present law, under the family code, that a number of organizations, you know, juvenile court, juvenile probation as part of progressive sanctions, they can refer people to at-risk services. We know that municipal and justice courts have been able to do it, but only on the back end of a conviction or a deferred order. Well, now they can also do it on the front end as part of a diversion. And last but not least, this has to do with judicial education. We already had a law that said in years ending in 0 and 5 that municipal judges and JPs had to have training on things having to do with the Individual Disability Education Act. My mom's a school psychologist, and I appreciate the importance of that, but I have to tell you, a lot of that stuff is really it was completely inapplicable to what municipal judges and JPs were seeing. So this bill changes the law to expand it. So now that training will include child welfare, including issues related to mental health and children with disabilities as well. So it expands that, and I think that's going to go a long way in helping judges understand what is necessary. All right, ladies and gentlemen, thank you for surviving the last hour with us. I hope that you've enjoyed it as much as we have.
This is the end, my only friend, the end of our